Before we commence public business, a decision needs to be made about whether to reduce the minimum lodging periods in respect of particular matters on the order paper. Those are the amendment and the amendment in P.68, commercial properties and leases, and also the question of P.94, management and maintenance of Havre site. We start with P.68 amendment, commercial properties and leases, lodged on the 5th of November by the Minister for Sustainable Economic Development, who isn't in the chamber. Yes. Minister. We are going to deal first with the shortening of lodging periods in relation to matters on the order paper, so members know what is being debated during this meeting. And we're beginning with the amendment that you lodged on the 5th of November to commercial properties and leases. Do you wish to make the proposition under Standing Order 26.7, the lodging period be reduced to allow the matter to be debated at this sitting?
Sir, I do, yes.
Do you wish to speak to that proposition?
Sir, yes, it's just to advise the Assembly, to the best of my knowledge, as recounted to me by my officers, was the amendment was lodged, I believe, in time for the cut-off at 9 a.m, but did not get processed within the Secretariat until later, and that's why we are here arguing for the shortened lodging period. So I do ask members to take that into account, and I hope you will allow us to lodge this later. Thank you, sir.
Is the proposition seconded? Does anyone wish to speak on the proposition? Yes, David Tullier.
Can I just ask for clarification? When the Minister says it was lodged in time for the deadline, does he mean that it was sent to the GREF staff? Because it's normal for a period of time. There's usually a delay between submission of a proposition and approval, which could be actually longer than a day in some cases. So would he just clarify that in the summing up? And is he blaming the GREF staff, or is it? I'm trying to figure out whether essentially it was submitted late, not enough time given, or whether it was simply an administrative error.
I should say, Minister, that the amendment itself says earliest date for debate 25th of November. So it does sound like it was more than a few hours late, the lodging. Well, that's what the amendment says on its face.
Sir, I was responding to Deputy Tullier. So my understanding is it was lodged at the deadline or minutes before the deadline. So no, not a day in advance of that deadline. But I believe that was still in order. I don't know. Irrelevant. I'm not blaming anyone. I'm not a blame game type person. I just wanted to try to show that we hadn't just left it 2 days till afterwards to lodge it. We were trying to meet the deadline, and in one sense didn't. So thank you, sir.
Does anyone else wish to speak on the proposition? I call upon the Minister to reply. Minister.
Thank you, sir.
Thank you. Those in favour of reducing the lodging period kindly show.
We have the vote.
The power has been called for. Members are invited to return to their seat. I ask the greffier to open the voting.
Hang on. Sorry. Sorry.
If all members have the chance to cast their votes, I ask the greffier to close the voting. I can announce the proposition has been adopted. 42 votes pour, 44 votes pour, and no votes contre. There is an amendment lodged by the Comité des Connétables. Connétable, do you wish to make the proposition that the lodging period be reduced to allow this matter to be debated as well?
Yes, I do, sir.
Sir, if I may.
Yes.
Sorry to interject, sir. I'm conflicted on this, as people will know.
We're dealing with the amendment of the committee
Oh, I beg your pardon,
in
I thought
relation
the leader
to
was
commercial
next.
properties and leases. We'll come to your conflict, I think, in a moment.
Apologies.
Is the proposition seconded? Does anyone wish to speak on the proposition to reduce the lodging period in relation to this matter? All those in favour kindly show. Thank you very much. Anyone against? The lodging period is reduced. Now come on to P.94 Management and Maintenance of the Havre site. Yes, P.94 St Clement.
So, as I said before, I'm conflicted on the Havre situation as I'm a director of the company who are trying to take over the lease. And I feel I should not be in the Assembly whilst this is debated, and I will certainly not be voting on the extension time.
Yes, thank you.
Thank you. May I take my leave?
You may. Deputy Ward, do you make the proposition under Standing Order 2067 that the lodging period be reduced in relation to this matter?
I do, sir.
Do you wish to address the Assembly in relation to this matter?
Yes, certainly. So events in this situation have been moving very, very rapidly. And because of that, I felt it necessary to put in my proposition, despite it being short-lodged. There is an expectation from the public that this is debated as soon as possible, and there is a protest anticipated tomorrow in line with the debate to support that debate. And also last Thursday, the Lido at Havre there was a very vociferous meeting whereby all those who attended that meeting were very, very keen to make sure that this got debated. As I say, so there's a high level of public interest in this. So I appreciate the Minister for Infrastructure has asked for a delay or to go back to a normal lodging period. However, from what I've heard, and I appreciate his commentary is around saying, I want time to find more information. The information, as far as I understand it, has actually been available to his department for at least the last 6 weeks. So to get a call 48 hours before the potential debate, I'm sorry, I can't accept that. So I hope members will support me on my short lodging period. Thank you, sir.
Is the proposition seconded? Yes, sir. Does any member wish to speak? Minister.
Thank you, sir. So I emailed members earlier today setting out my position, but for the benefit of the wider public, I'd like to say a few words in response to this request for a reduced lodging period. So members are aware that I was originally content to support a reduced lodging period when this proposition was lodged by Deputy Ward at the end of October in order that we could deal with the matter in good time. So throughout this process, myself and Constable Crowcroft have been determined to remain impartial and ensure that we run a fair and balanced process, and I believe that that is what we have done. I am, however, sir, like all members, of course aware that concerns have been expressed about the process. Following Thursday's meeting chaired by Deputy Ward, which the Constable of St attended as my Assistant Minister, I agreed to meet representatives of the Havre Lido group yesterday afternoon at 3 p.m. with the Assistant Minister and Infrastructure officers. So the group have criticised aspects of the expressions of interest process, and after our discussion with them, we believe it would be helpful for us to be able to look at those concerns in more detail before having this debate. The group advised us yesterday afternoon that they had commissioned their own review but weren't in a position yesterday to share either the detail or indeed advise us who had carried out the review. But we do take their concerns seriously, sir, but it's a bit difficult to do that anonymously. Sir, currently, on the face of it, we do not consider the Havre Lido's concerns to amount to valid reasons to question the process and would therefore maintain our opposition to P94. But, sir, out of respect to the group and following the meeting yesterday, we would rather look at those concerns raised by the group in greater detail and respond to them prior to the debate, instead of these concerns remaining outstanding at the time of the debate. So one of the things we discussed yesterday was charity registration. The group assured us at our meeting yesterday there was not a problem, and that has been confirmed today by Deputy Ward's email at lunchtime. The deputies asked me to withdraw R158-2025, the Standing Order 168, Sir, but I won't be doing that because I've made a commitment in writing not to sign a lease until the debate on P94 has taken place. And, sir, I'm happy to reiterate that position now and have it recorded on Hansard. Sir, also, potentially it would mean that a subsequent challenge to Standing Order 168 might not then be debated until the 20th of January, potentially leaving the property empty for a month. And this is where the Deputy War and I both agree we don't want to see empty properties unnecessary. So we need a resolution well before the 20th of January. So I recognise that I've changed my position on a reduced lodging period, but I think it is a reasonable response given the new information and the position we face. The impression I was given yesterday during what I would describe as a constructive meeting is that some of the Laval Leader group would rather that we allowed further time as well prior to the debate. I'm only asking that members allow the normal lodging period to expire before debate takes place, and that would enable the debate to be better informed. In the next fortnight, should members allow, we will explore the concerns raised by Laval Lido to see if they have merit. And sir, I'm open to ensuring that this is overseen with appropriate independence to ensure that it's both thorough and, importantly, is seen to be thorough. Otherwise, sir, I remind members that P94 seeks a complete subversion of due process, and if adopted, especially if adopted at this sitting, it will open us up to no end of issues and likely challenge in the months and years ahead. Sir, I will not be supporting the request for a reduced lodging period, and I ask members for their support. Thank you, sir.
Thank you, Minister. Does anyone else wish to speak on this proposition? I call upon Deputy War to reply. Deputy War.
Thank you, sir. And I just respond to the Minister there by saying that I have also spoken to the governors. They have no desire to see this proposition delayed. They want this debate to be held. As I said, I think the general public do as well. And I think it would be remiss of this Assembly to delay what is proving to be a very important debate for a number of islanders. And I think we need to listen to the general public. We need to make sure that we carry out their wishes. And I think it's of vital importance, despite the Minister saying he doesn't have certain information. That information, I can assure members, is all out there, has all been out there for the last 6 weeks. And it simply just has not been, no attempt has been made to try and reconcile and find out more information. I can go into details. My objective is to go into details in my speech about that, but some of those numbers which have been quoted are absolutely outrageous, and I think his department could well have put in the effort and the time to sort those numbers out. This will simply deflate the momentum behind this proposition, and as I say, I have a massive amount of public support for this proposition to be debated at this session. We've all receiving emails, significant numbers of emails from the public, and I think we would be absolutely the wrong thing to do to delay this debate still further. We need to lance this, we need to get this done and dusted, and tomorrow is the day to do that on. And I hope members will support me in that frame. Thank you.
Is the appel called for? The appel has been called for. I invite members to return to their seats. I ask the greffier to open the voting. If all members have the opportunity of casting their votes, I ask the greffier to close the voting. Announce the proposition has been defeated. 12 votes pour, 33 votes contre.
We have 12, please, sir.
Yes.
Those voting pour, do you want, sorry, pour or contre?
Both, please.
Both, please, right. Those voting pour the Connotabs of St Saviour and Deputies Tadier, Moore, Mezek, Balash, Coles, Hore, War, Miles, Kovac and Wilson. Those voting contre, the Connotabs of St Helier, St Lawrence, St Brallard, Trinity, St Peter, St Martin, St John, Rouville, St Juan, St Mary, and Deputies Southern, Labby, Luce, Doublé, Lehegara, Ayer, Rob Ward, Alves, Gardner, Scott, Renouf, Catherine Curtis, Feltham, Rose Binet, Jern, Miller, Howell, Ferry, Alex Curtis, Barbara Ward and Deputy Stevenson, and online Deputies Gorst and Binet, Tom Binet.
The next item of business is the suspension of Deputy Ozouf, lodged by the Privileges and Procedures Committee. I understand that, Deputy Balash, you have a point of order you wish to raise at this stage, is that correct?
Yes, sir. If I may raise 2 points of order for your consideration. Standing Order 21AA provides that a proposition to suspend a member as a neutral act, and I quote, must propose the duration of the suspension. Projet 96 states that the duration of the suspension is, and I quote, until his pending court case is concluded. There are 2 questions. The first one for you is, does the proposition mean that the suspension lasts until sentence by the Royal Court or until the conclusion of any appeal against sentence to the Court of Appeal? And is the proposition out of order for not specifying precisely the duration of the suspension? The second question is, if the proposition is ruled to be in order on the basis that the suspension continues until the conclusion of any appeal in relation to the pending court case, which might not be until the autumn of 2026, would the suspension continue in force if Deputy Ozouf had been re-elected by the public at the elections on the 7th of June 2026?
Yes, having considered the contents of the proposition and the report, my ruling is that the words "until his pending court case is concluded" is until he is sentenced by the Royal Court, which I understand will take place at some point early next year. So the proposition is in order and can be debated.
Thank you, sir. May I make a second point, which may be a point of order for your consideration? I'm not sure, but I would like to propose, without notice, under Standing Order 80, that Standing Order 21AA, paragraph 2, be suspended for the specific purpose of allowing a public debate on Projet 96. Paragraph 2 of that standing order provides the debate on a proposition lodged under this standing order must be held in camera. If that paragraph is suspended, the usual rule will apply and the debate will be held in public. And that is my purpose in proposing the suspension of the paragraph. So the greffier has drawn to my attention a ruling made by one of your predecessors on the 19th of May 2009, and I think I need not disclose who that predecessor was.
We all know who it was. It was one Sir Philip Balash, whose ruling you are now challenging. 16 years later.
A ruling made by one of your predecessors that on a literal reading, Standing Order 80 did not permit part of a standing order to be suspended. So it is always open to a presiding officer to vary a ruling given by one of his predecessors, and my contention is that in this case you should do so. And there are 5 points that I would make. The first is that the 2009 ruling was made ex tempore, that's to say without time for reflection or deep consideration. Secondly, as a general rule of interpretation, the greater includes the lesser, the a fortiori argument. If there is power to suspend the whole of a standing order, there is power to suspend a part of it. Thirdly, the 2009 ruling should be regarded as restricted to the standing order then in question, Standing Order 63(1), which limited in time the asking of an oral question, and should not be regarded as having a general application. For all we know, the presiding officer in question did not intend it to have a general application. The fourth point is that Standing Order 21AA2 infringes a fundamental rule of democracy, namely that debate in a democratic assembly should take place in the open so that people can hear what is said by their representatives. And fifthly, sir, it should therefore, in my contention, be open to members to decide whether or not to suspend the paragraph of the standing order in question in an appropriate case. Whether this case is appropriate will be a matter for debate if you allow the proposition to be moved. I'm not asking for a general ruling. You could rule only in relation to paragraph 2 of Standing Order 21AA. And I accordingly ask, sir, for your leave to move under Standing Order 80 that Standing Order 21AA2 be suspended.
Thank you, Deputy Balash. Standing Order 80 provides that a member of the States may propose without notice that one or more standing orders may be suspended for a specified purpose, and it has been understood for the last 16 years that that standing order does not permit suspension of part of a standing order. I accept that it is possible for a presiding officer to differ from the ruling of a previous presiding officer, but in my judgment, only in circumstances where they are satisfied that the early ruling was wrong. I note from Erskine May, the Speaker's rulings constitute precedents by which subsequent speakers, members and officers are guided. Such precedents are noted and in the course of time may be formulated as principles or rules of practice. They are an important source of determining how the House, in our case the Assembly, conducts its business. And it has been long understood that it was not possible or indeed appropriate to suspend part of a standing order. Indeed, those are the terms, in my judgment, of Standing Order 80. As to the suggestion that Standing Order 21AA infringes a fundamental rule of democracy, well, it is the Assembly itself that has determined that propositions to suspend a member for a certain action under 21A are determined in public, but propositions to suspend a member as a neutral act are to be held in camera. In any event, I'm satisfied that the interpretation that has held good for the last 16 years holds good today, and according to the proposition that you seek to make is not in order.
So I'm also interested to know whether Deputy Balash is saying he was wrong 15 years ago. I do have an interest, sir, as I think it may be me who moved the standing order, the ruling, sir.
Well, that's a matter that you can raise with him on another occasion. Now, before we commence the debate, I sent some guidance via the greffier to members earlier on, which you were informed I would read out before the beginning of the debate. I've been asked to provide guidance on the application of Standing Order 21AA, additional requirements for propositions to suspend member as a neutral act, and to remind members of the provisions of Standing Order 82, arrangements for conducting business in camera, and the consequential impact of such a suspension in relation to Standing Order 164, suspension of member of the States. Members may be aware that under Standing Order 107, the presiding officer may direct members not to refer to matters relevant to any proceedings pending in any court. Standing Order 104(2)G states that when speaking, a member must not refer to a case pending in a court of law in such a way as might prejudice the case. Clearly, those standing orders are pertinent to the proposition to be debated. However, given that the debate will take place in camera, the debate ought not to prejudice the court sentencing that will take place next year or the trial of the co-defendant. Members are reminded that once the greffier reads out the proposition, we will move into camera. All strangers are required to withdraw, the gallery will be cleared, and the public entrance will be closed. The individual currently in the gallery is a log noter from the gref, and she is present in order to produce a transcript and will be required to stay when we go into camera. The debate will not be broadcast on the States Assembly webcast, but will be recorded so a transcript can be produced as an historical record, but will not be made publicly available. Once the debate has concluded, we'll return to public forum and the vote will be taken in public. There may need to be a short pause in proceedings to enable the webcasting to resume. I would ask that members remain respectful of the in-camera process and keep any background discussions to a minimum during that time. I'd also emphasise that any public disclosure by a member of what was discussed during this debate held in camera would constitute a serious breach of the Code of Conduct. If the proposition to suspend Deputy Ozouf as a neutral act is adopted, Standing Order 164 would apply. Standing Order 164 does not remove an elected member from office. Its application simply limits the activity of a suspended member in the ways described. The Standing Order does not contain provisions in the event that someone is suspended as a neutral act in relation to attendance and participation in states meetings. The dictionary definition of suspension is an interruption or temporary revocation, and that must be the intention of Standing Order 164, whether in relation to suspension for certain acts or as a neutral act. Although the Standing Order does not specifically reference attendance at states meetings, including through remote participation, it must be the underlying purpose of suspension and therefore Standing Order 164. The other consequential effects listed in the Standing Order are additional to that fundamental. Part 1B of the Standing Order therefore prevents a suspended member from lodging a proposition, submitting any questions, or presenting anything to the Assembly. That reinforces and clarifies the conclusion that a member suspended, whether as a neutral act or as a sanction for certain actions, cannot participate in meetings of the states. Therefore, should the proposition be adopted, the Deputy's parliamentary activity must cease during the period of suspension. He may not lodge propositions in his own right or submit questions. He may also not take part in the proceedings of parliamentary committees and panels, including PPC and its subcommittee or scrutiny panels and the PAC. He may not attend briefings provided to states members. While Standing Order 164 affects a suspended member's parliamentary work in the way set out, it does not, however, affect their ability to work with and on behalf of their constituents or their entitlement to remuneration as a member. That work is an inherent part of their office as an elected member, and Standing Order 164 makes no reference to constituency work. A suspended member may therefore continue with their constituency work, although whether they do so is a matter of personal and political choice for the member concerned. That means a suspended member may still meet constituents and act on their behalf, provided that to do so does not involve the parliamentary work they are prescribed from doing. They may therefore correspond with government departments and others on constituents' behalf, and they may access those services provided by the state's GREF for constituency work. As a result, a suspended member must continue to have access to the Microsoft account provided for all elected members, so they can use their email account and can communicate. They would therefore continue on the email distribution and in the Microsoft team for all members. I also remind members attending remotely that they are bound by all the obligations in relation to this in-camera debate as members who are present in person. So we now move into camera.
So I do have a point of order. I think
Yes.
it's a point of order. I was asked before the meeting by a member of the public about the usual Hansard and the filming of this. I said I'd imagine it wouldn't be filmed because it's in camera, but that
Yes.
and that a Hansard, you mentioned the Hansard already, so is the Hansard being produced in the normal way, or are there special provisions being made for that? And given the fact that one of the prime drivers for this being in camera, although it's in the standing orders, is that there's an impending court case coming up. The question I was asked was whether, when the court case has been concluded, whether the transcript will ever be published at some point, and even indeed for, you mentioned a historical record, sir, in terms of, is it FOIable in 30 or 100 years' time, etc., under those provisions?
I'll discuss that briefly with the greffier. Yes, Deputy, the position is that it will not be recorded, it will be transcribed and password protected, and there will be a copy of the transcript available for members of this Assembly only to inspect if they need to or wish to at the offices of the greffier.
So just for the record, presumably it's not necessarily verbatim in the sense that when a transcript's recorded in the same way and it's outsourced, I still think it's done verbatim, whereas this will be a note form.
It is produced in the same way, so it will be accurate to the same standard I will revert to you in relation to the FOI question that you asked. Yes, Deputy Scott.
Yes, sir. Is there a definition of neutral act and is there a definition of constituency work? Because I note that the member, if this standing order is applied, can't lodge propositions or ask any questions. So in my mind, that can be part of constituency work. So a definition would be useful, sir. Thank you.
Well, you'll need to make do with the ruling that I've given, I think, for the time being. Yes, Deputy Morell.
Yes, sir. Just out of interest, during a period of suspension, may a suspended member refer to themselves as a States member?
They remain a member, so yes, they are entitled to refer themselves as a States member. So we now move into camera, and after the greffier has read the proposition.
The States are asked to decide whether they are of opinion to agree to suspend Deputy Philip Francis Cyril Ozouf of St Saviour as a neutral act in accordance with Standing Order 21AA with immediate effect until his pending court case is concluded.
We now move into